Good evening, ladies and gentlemen. First of all, congratulations on negotiating the rain to get here. We have an exciting 90 minutes ahead of us, focusing on the Abidjan Principles, which is a rich set of principles that's trying to engage with some crucial questions in the right to education space. And it's a really big privilege to have four of the people who are involved in the actual drafting on these principles right here with us today. So the event is actually sponsored by the Oxford Human Rights Hub, and of course Sandy Friedman runs that, and the Continuing Education Centre. And so we're delighted to bring academic staff, students, and various interested people together. The actual session consists of four separate parts. I'm just going to briefly introduce each of our speakers in a minute. And then the next substantive part involves asking them a series of questions with regards to either the background to the Abidjan Principles, so what problem is it trying to solve, some of the content in the materials, thinking through some of the controversies that existed both during the drafting process and since the principles have come into force, so to speak, and that legal question about where do they stand, what's the standing that these principles have. So what I intend to do is to put those questions on behalf of all of us to our participants one by one, and then we will have quite a lot of time for you to get engaged as well, having got some of this background, and we'll wind up just with a few final thoughts from each of our panelists. So without further ado, let me just briefly introduce them. Anne Skelton, you have right here, Professor of Law at the University of Pretoria, where she holds the UNESCO Chair in Education Law in Africa. She's also the Director of the Centre for Child Law, which promotes children's rights in South Africa through advocacy, law reform, research, and litigation. She is a practicing lawyer who often appears in South African courts, arguing landmark children's rights cases. She was the head of the drafting committee of the Abidjan Principle and is a member of the United Nations Committee on the Rights of the Child. Anne Skelton. Should we give her a round of applause? Next up is Sandra Friedman. Sandra Friedman is Rhodes Professor of the Laws of the British Commonwealth and the USA at Oxford University. She was elected a Fellow of the British Academy in 2005 and became a QC, that's Queen's Counsel, honoris causa in 2012. She is Honorary Professor of Law at the University of Cape Town and a Fellow of Pembroke College, Oxford. She has written and published widely on anti-discrimination law, human rights, and labour law, including numerous peer-reviewed articles, 3 monographs, and 2 co-authored books. She has acted as an expert advisor on equality law and labour legislation in the European Union, Northern Ireland, the United Kingdom, India, South Africa, Canada, and the UN, and is a barrister practicing at Old Square Chambers. Sandy founded the Oxford Human Rights Hub, and thank you, Sandy, for putting this event together, of which she is the current director. Sandy first. Magdalena Sepulveda Carmona is next, who is a senior research fellow at the United Nations Research Institute for Social Development. From 2008 to 2014, Magdalena was the United Nations Special Rapporteur on Extreme Poverty and Human Rights. Dr. Sepulveda's 20-year career at the intersection of poverty, development, and human rights has bridged research and activism. She has worked as a researcher at the Netherlands Institute for Human Rights, at the Department of International, as staff attorney at the Inter-American Court of Human Rights, and as co-director of the Department of International Law and Human Rights of the United Nations mandated University for Peace in San Jose, Costa Rica. Magdalena is a Chilean lawyer with a JST from the University of Valparaiso, an LLM from Essex, and a PhD from Utrecht University. Welcome, Magdalena. And last but not least, of course, is Maria Smirnova, who's Associate Human Rights Officer at the Office of the United Nations High Commissioner for Human Rights in Geneva. Her PhD dissertation, completed in Moscow in 2006, was dedicated to the constitutional right to education and guarantees of its realization in private educational institutions. Dr. Smirnova worked as a researcher in Moscow-based Federal Center for Educational Legislation, engaging with projects commissioned by the Russian Ministry of Education and Science, including participation in the drafting of the current federal law on education in the Russian Federation, a codified act comprehensively regulating all types and levels of education in Russia. From 2014 to 2017, in her role as research associate at the School of Law at the University of Manchester, Dr. Smirnova has made a significant contribution to the ERC, that's the Research Council funded project, establishing the connection between the constitutional development and the use of international human rights law by domestic courts.
limelight.
We can take you out of the limelight. Now that we have our colleagues highlighted, we can... No, that's not all off is not all on. Let's try all on. They did promise me that I could just tap it and it would disappear. I'm obviously not doing it forcefully enough. No, that doesn't work.
What if we... There we do.
Now, blank projector. There you go. Yeah, like many things in life, you get there eventually. Right, so we're going to start with some background principles, and I guess, Anne, the first question really would fall to you. So what specific gap is the Abidjan Principle trying to speak to, regulate? What is the actual problem that the Abidjan Principles are seeking to try to fix?
I think it's clear that international law recognizes the obligation of states to provide education. But at the same time, it does allow the liberty to individuals to establish private educational institutions. However, states are required to regulate that in terms of the international law to ensure that it doesn't go against equality, that the standards are similar, and also that it doesn't have a negative effect on equal access to quality education for all children. And so in practice, however, although that all seems to be very easy to understand in the law, but in practice what's been happening is that in some states, the private sector has engulfed the education system. Sometimes this is historical, where religious schools have always played a very important role, and in some instances it is about the moving in of people who treat education as a good, a market good, something you can buy and sell. And where it is not, parents think that they're getting something better for their children, but sometimes they're actually getting a poorer quality education, but paying for it. So they're really being shortchanged at both ends there. And so this really is about, first of all, saying we need states to be clear about what their obligations are to provide a strong public education system, and also to ensure the regulation of private education, understanding, of course, that that's a wide range of role players, from non-profit NGO through all the way to big business.
Thank you. So, Sandy, there are a number of issues here that obviously would be a source for some discussion with regards to privatization and education. But I guess maybe first, if you could just address the question on socioeconomic rights itself, and how is it that these principles try to overcome what are often defined as vexed questions around a minimum core, progressive realization, maximum availability of resources. How is it that the principles try to square, I guess, many of these debates?
Yes, so this was one of the challenges that we faced. So I think, as you will know, in defining socioeconomic rights, many of the international instruments, particularly the International Covenant on Economic, Social, and Cultural Rights, talk about some of the rights being progressively realized subject to maximum available resources. And one response to the seeming postponement of the duty endlessly has been to try to create the concept of minimum core. So the minimum core is the part of the right that has to be realized. So when we came to do the drafting, we obviously had to have some sense of what is the content of the right to education, and correspondingly, what are the duties that follow from the right, the duties on the state, which include respect, protect, and fulfill. And in doing so, we, as you might know from the International Covenant, the right to education is specified as being compulsory free primary education, which looks like an immediate right, which could be seen as perhaps a minimum core, and secondary education, which is the covenant says it should be made as accessible as possible and free progressively. So progressively, it should be made free. So our initial instinct was to think of defining the right in terms of a core, which might match this division between primary and secondary. But as soon as we started discussing this, we started hitting the boundary. Does secondary fall into the core? But free secondary become progressively realized. And the more we grappled with this boundary, it became clear that one of the risks of this division between core and progressive realization is that anything which we put onto progressive realization looks like it's only aspirational. It didn't seem to be, and many even round our table were, well, that's not part of the binding right. So we came to the view, which I think was a really important one, that the first stage is to define the substance of the right, not to divide it up between core and progressive realization, because we need to know what is the whole right, and we need to reaffirm that all parts of the right are binding, including free secondary education, including preschool and the other things. It's just a matter of specifying what are the priorities. So you'll see from the principles, if you look at when you look at them, if you look at them in detail, that we have a separate section on the nature and scope of the right, which sets out the right in its the full nature of the right. And then we have a separate section on state obligations, which not so much, although we have a mention of core, we talk about prioritizing. So we say states must do these things first. And that got us out, I think we had all been conscious of this conundrum, but this was one of the ways in which we dealt with it, by making sure that everyone was clear about the full scope of the binding right. And the fact that some of it can be postponed doesn't in any way detract from the bindingness of the right. The other part, which is maximum available resources, is also very easy to slip into being just aspirational.
Yeah.
A state can say, we'll just gather our resources whenever. So we also wanted to prevent it from slipping into that. And one of the ways we did it was, firstly, to have a broad definition of what are the resources the state should be counting, which includes countering corruption, proper tax collection, countering tax avoidance and tax evasion. But also, what we said was that maximum available resources had to fall above a minimum available resources. So a state could not simply say, we're going to put so few resources in. And the guidance that we put in was that these maximum available resources should not fall below what has been agreed internationally as the percentage of GDP, for example, for development goals or other things. So that's how, in the committee, we discussed and we came to these conclusions on that issue.
Thank you very much. Magdalena, could you reflect a little bit? I mean, you've been Special Rapporteur, and I guess even as Special Rapporteur, you have states constantly questioning the legitimacy of the office and the extent to which it can do work. And here you are in a situation where this is an expert-led initiative that has yielded some Abidjan Principles. Could you reflect a little bit about the legitimacy of the principles and the drafting process, perhaps?
From the very beginning, the task was to really try to identify and clarify the existing international norms that related to the provision of state services in regard to education. However, and that requires to look into all the different sources from the different treaties, the jurisprudence of the UN treaty bodies, and regional jurisprudence on the topic. And all that was done. But of course, that is much easier said to done, because there is a lot of tension, as Anne mentioned, several issues that were not clarified, as Andy clearly gave very clear example. So there is this very fine balance between how progressive you can be in finding this contemporary interpretation of the existing norm, and at the same time trying to keep it in the boundaries of what is the existing law. This is not a new exercise. So since the early 80s, we have experts coming out with guiding principles. We have the famous Lindbergh Principles, the Maastricht Guidelines, the ETO and extraterritorial obligation. We have several initiatives that have been run outside intergovernmental processes. And many of them have become very authoritative and legitimate. So I think that the legitimacy depends on several factors that one needs to take into account when you're doing the exercise, and also it should be also analyzed afterwards. So if we look at, for example, one important component is diversity. So diversity of the drafters and diversity of the signatories. If we look back, Lindbergh Principles, the Syracuse Principles on limitation and derogation in '84, only men, only professors of international law, and from very few countries. Things began to get better as time passed. The ETO, the extraterritorial obligation principles, have a much more diverse list of drafters and signatories. And I think that diversity is, of course, one critical criteria that one needs to look. Of course, the independence and the expertise of those involved. And here it is not only, and of course, it's not only the drafting committee, but the conveners of this. I mean, you always have a smaller group of people that are leading the process, of the ones that seek funds to do this and are really trying to undertake everything else. Then it's consultation. This process is very different from previous guiding principles because it was planned to be very consultative. So there were several consultations with trying to bring the diversity of knowledge. So the drafting committee, it's mainly more a legal expertise, but all those with different sort of diverse knowledge on education were brought to the table through many consultations that are very time consuming, because you also need to explain to them the objective of a legal, what is going to be at the end a legal document. And sometimes advocates would like to be very progressive, and that is again another negotiation, another balance, because at the same time, on the other side, you're trying to have a document that somehow seeks to reflect international existing human rights standard. You have several other factors, the preciseness of how precise are the texts, and I think that all of this the Abidjan Principles have to comply with them. Another important one is the validation. So the more these principles are validated afterwards, the more legitimacy they gain. And all these factors, I mean, are not linear. Yeah. There are many, if we look back at the past experience of these type of processes, it depends on who promote them, or who students identify, or academic or judges identify as being the leader of the process, etc., etc. And sometimes the impact of these documents are also very anecdotal.
Thank you for that. So I mean, so far we've looked a little bit at I guess what it is that the Abidjan Principles are trying to solve. We've looked at how they've dealt with what have traditionally been bugbears in trying to frame socioeconomic standards, and we've tried to understand a little bit about the process of what gives a group of experts the right to feel that they can write up a set of documents that they hope states will apply. But Maria, so far we haven't really talked about the content of the instrument. Now, obviously, with all the students in the room, we have to say you need to read the entire document. You need to read it very closely, and you can maybe examine on it. But there are 10 guiding principles that you could maybe take our participants through. And could you just articulate on those principles, please?
Sure, thanks. Before I do, I just make a compulsory disclaimer that I'm here in my personal capacity, and my views are my own and don't reflect the position of the office. So they're done.
Which of course is completely supportive of principles.
So the 10 overarching principles, as we've called them, is a shortcut, but at the same time it's not. So during the work of the drafting committee, during the months of work with the documents and the days and the nights in Abidjan, where we were negotiating the content of the 97 guiding principles, there were many ideas. They had all to be reflected in the text, and the text was growing and growing and growing. So the idea behind the 10 overarching principles is to summarize, to give a rough outline of those main legal claims that these principles make, and to make it in a sort of a structural way. So you have the 10 guiding principles in your brochures. I'm not going to go through them one by one. I'll just explain the main idea behind this. So first, the 10 overarching principles correspond to the structure of the main text. So roughly, you will see in the text of the Abidjan Principles chapters and subchapters that are summarized in the principles from 1 to 10. If you look at the title of the Abidjan Principles, you will see that they have a twofold aim: to provide public education and to regulate private involvement in education. And these two aims are reflected in the 10 principles as well. So, for example, Principle 2 reflects the first aim, the provision of public education. So states must provide public education of highest attainable quality and so on. At the same time, Principle 4 reflects the second aim, the regulation of private actors in education. Then if you look at Principle 3, the text wouldn't be balanced if we didn't recognize the liberty of parents or legal guardians to choose for their children schools that are other than state organized schools, or to establish such schools. So Principle 3 gives this balance, liberty versus obligation of states to provide public education. Principle 5 gives a very important balance again, but at the level of funding. It corresponds to Chapter 4, financing of educational institutions, private educational institutions, and it reflects the idea that yes, private schools can be funded, but there are very strict requirements that they must comply with before they can claim such funding. Principle 6 addresses the problem of foreign donors and irresponsible investment. So it talks about international assistance and cooperation in providing funding for such funding that should first support public educational system and only after that potentially private educational sector. Principles 7, 8, and 9 are reflected in Chapter 5 of the Guiding Principles. It's on accountability, monitoring, and remedies. And Principle 10 talks about the implementation of the Guiding Principles as a whole. So this is how the 10 overarching principles give you an idea of the structure and the main claims that the whole document is making.
Thank you, Maria. Sandy, if I might turn to you. So you've heard words like private, finance, all of those things in there. And of course, we know that in the world of education, poverty and grinding poverty at that is a fundamental reason why many kids don't get to school. So could you maybe say a little bit about how the text deals with the question of equality and non-discrimination? And also, I guess, if there are any affirmative action measures or positive obligations created as a consequence for the state to specifically address the needs of poor and vulnerable families.
Yes, so clearly the poverty is really central to the whole motivation of these guiding principles, because if you look at figures on access to education and on out-of-school children, they are overwhelmingly concentrated in poor families, and as well, not just in poor families, but in an intersectional way, racialized, gendered, disability-based inequalities in access to education. So in some important ways, low-fee private schools could be seen to be kind of moving into a gap, and sometimes are advocated in that way. But actually, the poorest learners cannot access even these lowest fee private schools. So we're not talking about posh private schools. We're talking about commercial low-fee schools that move into areas where the public education system is failing, or in any case, that they think that there will be a market for their schools. The problem with that for poor children is that on the one hand, fees even at their lowest are too high for poor families, but on the other hand, they often are a pretext for states to run down the state education system. So, and we see that in many countries, that privatization of education goes together with a degrading sense of public education. So a lot of the motivation around state regulation of private education was to improve the access of the poorest children and improve their ability to access good quality schools. So when we were drafting the principles, on the one hand we had that in mind, on the other hand we wanted to include these kind of needs within our concept of equality and non-discrimination. On the one hand, of course, equality and non-discrimination includes the fact that you have a right to have a private school, so religious discrimination, you have a right to opt out of the state system. But on the other hand, equality and non-discrimination should also make sure that there isn't discrimination on grounds of race, gender, disability, and aggravated by poverty. Generally speaking, non-discrimination principles tend not to really see poverty as an express issue. So we needed to be able to incorporate that into our understanding of equality. And we did it in various ways. The one is to actually sort of mainstream equality throughout the document, so that you'll see there are lots of references to inclusive education which is inclusive. But also when it came to the definition of equality, we used several different definitions. We used the four-dimensional conception, which I've been developing for a long time, has now also been used by the Committee on Rights of People with Disabilities. And the important part of that is that it expressly says that one of the aims of equality is to redress socioeconomic disadvantage. But it also says that there are other dimensions, because we didn't want to heighten the stigma that's often attached to poor children, even if they do get vouchers or special provisions to go to schools. There's often a stigma attached to them. The third dimension is about voice and participation, that people should be able to express their wishes and their desires. And the fourth is to have a structural change to recognize that to be really inclusive, we need schools which can accommodate disability, gender, religion, race, etc. For example, by not expelling pregnant girls from school, by making proper provision for reproductive health in schools, proper accommodation for pupils with disabilities. So having set up that concept, we were also able to then say that it was a breach of equality to have segregated schools, because one of the implications of privatization is often to segregate in de facto poorer children into poorer quality schools, and to insist that everyone has the right to good quality education, regardless of their social position.
Thank you very much. So that hopefully has whetted your appetite to read the actual principles themselves. But Anne, I'm afraid you're going to have to answer some of the controversial questions that perhaps our audience might also engage with later. Surely if you're thinking about a human rights-based approach and you're thinking about equality and non-discrimination in society, you want one education system that treats everyone the same, or maybe not. I mean, so how do you deal with the issue of the private question, the private education question, and what space it occupies and the potential it has to segregate?
I think looking at these principles, some people might feel that the principles appear to be anti anti the idea of any private schools existing. And so the question is that, you know, what we were trying to say? Are they discouraging privatization? I think the answer really here is no. What we're talking about is regulating privatization, because we started from the position, and we could do nothing other, because the international law is very clear on this. People have a liberty to establish their own schools and to pursue educational goals, as long as they are in keeping with the standards and norms that are required by international law. Now, the issue, though, is that I think we have to, some people feel that one mustn't go too far in giving the state all of the obligation and power. Because what if this is a state that wants to impose a particular kind of educational regime? So I was often thinking about and shared with my colleagues a few times my disquiet about, think of, you know, Nelson Mandela. If he had had to put up with what the apartheid government was going to dish him up for education, he probably wouldn't have been the educated man that he was, and he actually went to a private school run by a religious, a Catholic, not Catholic, sorry, a Christian educational institution. And so one can see that it is very important. That liberty is there to also guard individuals against autocratic states that want to impose. That's the one side of it. But the other side of it, on the other hand, is that we shouldn't let states get away with thinking that they can leave someone else to provide education. This is surely the state's responsibility. And where we see that states are kind of taking their foot off the accelerator because somebody else will move in and provide, you know, low fee but often low quality private education, that is not acceptable, because what will eventually happen is that even if those fees are not so much, as Sandy said, some children won't be able to pay them. They will end up in the dwindling, pathetic education system that's being provided for by the state. So we were very much trying to remind everybody that it's the state's obligation to provide education. Others may do so. That should be regulated, but really we were saying, let's focus on the state's obligation.
I mean, this consent of the parents idea, I think, is obviously a crucial one also in the United States' position with the Child Rights Convention. But how far do you go? I mean, for instance, there are occasions in the Myanmar context where private Buddhist schools have been putting out information saying that it's the Muslims that are foreign here, they're the ones who are polluting our culture. And then you try to take a case and well, it's not really a state school, it's a private school. How do you deal with that question of the liberty to have an ideologically based school that may be at odds with the rights of others and may be at odds with the need to create a cohesive, well-knit community?
Yes, well, I think that is where the regulation comes in. And if we have regulations that require that any independent schools, any private schools have to have conform to standards that are set by the state, then that is less likely to happen. But those standards shouldn't be set by an autocratic state because they want to impose a particular kind. They should be in conformity with international human rights standards.
Okay. So let's just maybe finish off this part of the, just by thinking through what the future of these principles might hold. And we discussed a little bit, Magdalena shared her thoughts on the trajectory of where it goes. Maria, and not in your capacity as working at the Office of the High Commissioner for Human Rights, could you say a little bit about the traction? Because it's been quite remarkable for principles that essentially only were articulated in March, for us to be here in July, and it has quite a lot of traction. Could you say perhaps a little bit of what that traction is and also why it got such traction?
Yes, in fact, after the adoption in February, the principles have been already taken on board by civil society, discussed by states, they were discussed in the Human Rights Council session, and even made their way into the Human Rights Council resolution on the right to education this year. So I'll give a couple of examples. For example, in Uganda, the Abidjan Principles were referred to in discussions with the Ministry of Education, how Abidjan Principles could be implemented to ensure that nobody is left behind, and all children have access to good quality public education in the first place. Then in South Africa, the Abidjan Principles were referenced in a submission made to the South African Constitutional Court in a case involving unlawful expulsion of a student. So again, they're making their way into jurisprudence. Then a number of NGOs prepared a joint paper addressing the states of the G7, inviting them to implement Abidjan Principles in their internal policy making. Apart from the practical side, the Abidjan Principles were also recognized by the academia, and they were published in International Human Rights Law Review in 2019, which means we could expect more debates in the academic society about the nature and the purpose of these principles. Importantly, the states and international organizations also begin endorsing the Abidjan Principles. So in June, there was a resolution of the African Commission on Human and People's Rights, and the Abidjan Principles were accepted as guidelines for states to meet their international obligations when it comes to providing education. And finally, the process that I witnessed was the discussion of this year's report of the Special Rapporteur on the Right to Education. She reports annually to the Human Rights Council, and this year she dedicated her report and the presentation to the implementation of Sustainable Development Goals in the context of private involvement in education. And she actually dedicated a lot, like many pages of her report, to Abidjan Principles, and she recommended the states to implement them fully. And she also included the 10 overarching principles in the annex of this report. So based on that, there was a discussion at the Human Rights Council, and many states referred to the principles as an important guide for states, a useful tool, even innovative reference tool for states, and engaged very constructively with the text of the principles. And it's very interesting to actually hear them engaging, because you can hear that they actually understand they understood rightly what was meant by the principles. And most importantly, finally, the principles were referred to by this year's resolution on the right to education, Human Rights Council resolution. The resolution was adopted by consensus by 47 members of the Council, and it notes the development by experts of guiding principles and tools for states, such as the Abidjan Principles on the human rights obligations of states to provide public education and to regulate private involvement in education. It's very important that the resolution was adopted by consensus. Nobody called for a vote, although there were internal discussions whether and how we would refer to the guiding principles in the text of the resolution. But now it's adopted, and the civil society and the states can use the text to promote those ideas that are in the guiding principles in their countries and in their domestic context.
Thank you. I mean, something being adopted by consensus in the Human Rights Council in today's climate is pretty remarkable, you think. But so Magdalena, there's a consensus in the Human Rights Council. A couple of states have mentioned this. What is the legal weight still of this particular document now, you think, and where is it likely to go?
Well, first, I would like to kind of continue with what Maria said and just highlight that the guiding principles, in my view, came to really fill a protection gap, that it was very necessary, because we were seeing an increased privatization of education, in which, as it was explained before, these are low fee private school that provide very bad quality education, that are really going into areas and the state is retrieving. So where they go, where these companies go, to offer these services in several regions, then the state do not go because they let them to grow, and they provide a very bad education. So this situation is really impacting on the critical role of education as the way it's an enabling right, that it's one of the few vehicles for marginalized and people discriminated to really lift themselves out of poverty. So this crucial component of the right to education was under threat, and these guiding principles try to fill that gap. So in terms of the legal weight, it is a soft law document, but that is a little bit confusing because at the same time it is based on existing international human rights law obligation. So when they refer to existing obligation, they're legally binding, whether or not the state adopt the principles. It's just the sources of international law is somewhere else. But then we have also seen that the most important objective of these guiding principles, in particular when they have been developed by outside the intergovernmental process, is really to try to achieve their implementation at the domestic level. So this required additional advocacy to bring the principles at the domestic level, and we have seen and into other treaty bodies. So, and this is what has happened with other principles worldwide. So we see that some principles, for example, and this is kind of the potential future for this principle, no? Some, like the IDP principles that were developed with a little bit within the intergovernmental process, because it was the representative of the Secretary General for internally displaced person, ended up being the main source of the Kampala Convention, no? The IDP Convention. So these principles might end up being adopted in a legally binding instrument. We have also seen in several important cases around the world that guiding principles are applied in regional courts. The latest advisory opinion of the Inter-American Court of Human Rights, for example, used one of the most controverted expert principles, the Yogyakarta principles, and they use it and quote it and recommend them for all the states in the Americas. And that is really a very controverted for many regions. It's a wonderful document, but it is controverted by many countries about that document. And now it is part of an advisory opinion that is legally binding for the states member of the Inter-American system. Sometimes we have principles that have been used in important jurisprudence in high court. The Colombian Constitutional Court, for example, have also used the IDP principles. There are many other cases in which the principles of forced evictions have been used. So this is what we expect. What the final aim is the principles to be implemented at the domestic level. The validation by international human rights monitoring bodies, the political bodies, the African Commission, the Human Rights Council have already endorsed them. This is, of course, very good news in a very short period of time. We need now that the UN treaty monitoring bodies start using them in general comments, in concluding observation. That will sort of also help to validate and legitimize the principle. But then, of course, the important part will be part of them be adopted in national laws and then implemented in national courts. That is what we expect. That is the future. But actually, from my point of view, the fact that we have seen this validation of the principles in such a short period of time, it is a very good sign, and hopefully we're going to see the implementation in different parts of the world coming shortly afterwards. Hopefully.
Great. Thank you. So, Anne, a final question before we go to our audience. I mean, as chair of the drafting committee and as a visionary on child rights issues, I mean, Magdalena's talked about what could happen in terms of its legal development. What do you think the principles could do in terms of the right to education? What aspiration would you have for them?
Well, ultimately, I suppose what we want states to do is to invest in their public education systems and ensure that private privatization doesn't encroach or affect that negatively. And this also speaks to international cooperation partners and asks them to also not invest in privatization of education, but rather in public education systems. So it has a broader impact in that way. And so I think that what we're hoping for is that the ultimate effect, which obviously may take some years to be felt, is that we'll see states turning more towards the investment and consolidation of their public education system. But to add on to what Magdalena was saying, we also are looking forward in the short term to lots of debate and discussion, and we want academics to examine and debate and to talk about these so that they become the subject of critique and discussion and become more widely known.
On that note, let's have the discussion. Nazila, please. Please do raise your hand and introduce yourself. So I can...
Hi, I'm Naz Gunning. I wondered why there hasn't been more reference to SDGs. I know from Sandy's work that must have been a conscious choice of the drafting committee. So I just wondered what the rationale for that was. And regarding overarching principle 5, I couldn't read it in full. It's too small on my phone, but I'm sure to do so later. But I wondered if you had thought about spelling out some of the duties of private schools that receive government money, if you haven't already done so in some of the detail. Thank you.
So 2 questions, SDG and then the private schools. Who wants
Do you
to?
want to answer the SDG question?
So the SDGs are obviously a really important target for 2030. The controversial part of it is that they also say that it could be done through private means. So we didn't want to buy in entirely to what the SDGs agenda in the respect of the means to the end. We wanted to endorse the fact that they are very ambitious aims for education by 2030, but and also the fact that the SDGs now commit the world to binding human rights. So in a sense, what we hope, and I hope others share this, is that the Abidjan Principles will be guidance for the SDGs, so that when they are monitoring the extent to which we are achieving the SDGs, they will bear in mind that this little strand in the SDGs about privatization is not actually human rights compliant in the way in which the whole body of the SDGs claims to be. So even so I think it was this year that education has been one of the themes.
Yes.
Last month
Yes.
was one of the themes. And I think there was a lot of push within the high-level political forum around the monitoring of the SDG on education against privatization. So we hope that these principles can help strengthen that voice within the monitoring stream.
But if I can just add, I do remember 2 things that where we did look at the SDGs as being part of why we could, where we could position ourselves on what the international law was. One was on early childhood education, because although none of the instruments talk about it, SDGs did, and states seem to fully accept that responsibility. We didn't think it would be at all controversial for states, despite the fact that it isn't actually in the human rights standards. And then the other area was looking at secondary education being free, ultimately free for all. We also agree that can't be controversial anymore, given the SDGs.
Magdalena, you want to add something?
Yes, so that is one of the many tensions within the SDGs. So you have this positive side that Anne show in terms of education, but the PPP, and this is not only the position of the SDG, the private-public partnership, as a main way of implementation, is the position that more and more the UN as a whole and the Secretary General is taking. So I think that these principles come at a very precise time in which it is possible to kind of put a red flag and say, stop, hold on a minute. I mean, there is certain areas, in particular regarding the provision of public services, being education a key aspect in which PPPs can make more damage than good. and you have to have them regulated. And there's very little discussion about PPPs and human rights and PPPs and education, and the guiding principle, the Abidjan Principles, really address this issue directly.
On that, the second point, which was about
So, I think Maria wants to weigh in on the first point as well, please.
Thanks. Also on PVPs, while we're here. In fact, during the discussion in Human Rights Council, every fourth state that spoke during that discussion asked the Special Rapporteur, surprisingly, what are we going to do with PPPs? Do you have any good practices on how PPPs can actually benefit the education system, or what are we going to do with them now in light of SDG 17? Yes. So, do you want me to answer the?
Do you want to start, and Anne can maybe carry on? So, yes,
Yeah?
please.
Okay. So on the Principle 5, Principle 5, overarching Principle 5 says that states must prioritize the funding of public education first, and may only fund eligible private educational institutions if they comply with human rights law and standards and strictly observe substantive procedural and operational requirements. And to answer your question, when we go, if you look at chapter 4 on financing of educational institutions, you will see a very detailed list of substantive, procedural and operational requirements, which basically say what should private schools do, first to receive funding, second to retain it, and third what can they do with that funding. So that is a very regulated, well, we say regulated, but in fact these are recommendations, of course, which the states could endorse in their policies, but they're based on a very strong jurisprudence of UN bodies and courts. So it's all there, and it's a long list, so it's possible to use it as a guidance of what private schools can do with their funding.
And you wanted to add to that?
Well, I just remember that this one was one that I kept on tripping over when in our discussion, and it felt like we were becoming too extreme in over-regulating this part of it. And I'm actually quite cautious. I mean, I'm by no means a radical on the drafting group. So I was going, but aren't we going a bit far? And then Sandy would always remind me, but we're only talking about funding of private schools. We're not saying that private schools can't exist, that they can't do whatever they want to. It's just about whether the state should fund. And we don't go so far as to say that the state can't fund either. We simply say that they should only fund in these kinds of situations and for these kinds of services and so on. So yes, Sally had to keep reminding me that we're okay, we're still on track.
Yes, please, Tamilo.
Two questions. One, regarding funding of public education, did you address exactly how to do it? For example, in the American state I'm from, it's funded through property tax, whereas in other states it's funded through, let's say there's a pool of money and the state government decides which school is the most needs the funds and distributes it that way. Have you addressed which way is better? Because from my understanding, the property tax model is a way that just inherently breeds inequality in education.
Who wants to tackle that? How is it funded?
I can go. There is no precise information on how, but there is very precise regulation in terms of stopping a state claiming a lack of resources or austerity measures in order not to fund education. So basically the principles go to say that they need to sort of open the fiscal space and grow their fiscal space through different means in order to have the necessary available resources to fund education. But then it doesn't go into very precise detail of what is the best, because there is no one-size-fits-all solution. It depends on several circumstances. The important part is that the state must take a step to increase their fiscal space, to have the resources in order to fund education, public education.
Can I add to that? So this also comes back to the equality point that that we all talked about before, which is that although we don't say what model of funding is best, we do say that funding should not have inequitable outcomes. And probably, a property tax like the US, some US states do does have that inequitable outcome. So the state would need to have some kind of redistributive mechanism to make sure that the equality principle, particularly the equality on grounds of socioeconomic disadvantage part, is fulfilled.
So practically, someone taking a case to court, for example, in that particular state, could try and argue using the Abidjan principles. Of course, the court might say, well, we haven't even ratified most of the underlying instruments, so we're definitely not looking at these. But in some states, it might work.
I don't think it's going to stop Damilola from asking her.
But
There's
actually,
a question there.
Just to add, that before you come to that, there was an interesting few court decisions in US states which said that the state could not allow private schools to drain funding from the public budget, and we did use those cases. So it's not all bad in the US courts.
So we have a question there. I'm sorry, I don't know your name, and then we have a few more. So please.
That's right. My name's Marie. I'm an Australian lawyer, but a master's student at the University of Oxford, and have also spent the last 9 months working in the UK. In one of my roles in the UK, I was working for a regulator, albeit not an education regulator, and I did come across a case which does concern education. Basically, in the UK, the government is rolling out the relationship sex education program and essentially making it mandatory for schools. My role came in where there was a psychologist coming out and saying all sorts of things against this program, and we were regulating the psychologist in her role in her capacity as a psychologist. And her arguments were that this program, which is essentially designed to promote non-discrimination and equality of LGBTIQ students, this was encroaching on, I think, the schools, particularly private schools, religious schools. This was encroaching on religious freedom. It's a difficult concept and a difficult sort of argument to have. In my view, obviously, I'm all for promoting non-discrimination and equality, but obviously some parents, particularly those who are supporting this campaign against this program, some parents feel like it is taking away their autonomy to choose what they educate their children. So,
Good question, Marie. Any comments on that one? It's a really quite a raging controversy here at the moment. So,
yes. And unfortunately, I did lose my case, but that's
any comments on it? Are the principles relatively silent on questions like that, or do you think the catch-all on the human rights values that are in the principles themselves, laced through the principles? Do you think that they would give somebody like Marie in a court of law a chance to say, here's a human rights-based approach and this is why it's wrong?
Well, I think the right to freedom of religion and the right of parents to choose religious education for their children is certainly there in human rights law. But it's also subject to an overriding equality perspective. And so, again, the Abidjan Principles don't really deal with this kind of detail, but the background principle would be that it's more and more being accepted that comprehensive sexual education is part of the right to equality and is part of the state's responsibility in ensuring good quality and inclusive education for everyone. So I think certainly the background principles of the Abidjan Principles would include that the right of parents to choose religious education and to run education institutions is subject to the broader norms of the state, which would include equality norms, particularly on grounds of sexual orientation. So,
Yeah, I mean, I think the same thing would apply, for example, for corporal punishment being retained in private schools, where several cases have found that can't override the need to protect children and treat children equally across different educational settings. So it might depend on the legal frameworks within the country concerned. But I although it doesn't go into this much detail, I think that the overarching message is what we want is equality, and you can't privatize yourself out of that to at the expense of other human rights protections.
Okay.
Yeah, I also think, just to add, that the principles are based on the issue of diversity. in a way, the inclusiveness and diversity. It's a core principle within, promoted by the fact that you have to have public education accessible to all. So there are several type of arguments and sort of regulation of content in the Abidjan Principle that will support diversity in that sense, including diversity of sexual education.
At the same time, being on the devil's advocate side here,
Surely not on the devil's advocate side.
there is no universal consensus on such a problematic issue as comprehensive sexuality education. And I will give you one example, very quick example. During the last session of Human Rights Council in June, the Council was extending the mandate of this independent expert on sexual education, sexual orientation and gender identity. And that was a very, very difficult mandate to extend. So there were 10 amendments submitted to the resolution which only said extend the mandate.
Yeah.
And some of them, or most of those amendments, dealt with the issue of comprehensive sexuality education or other little issues that have to do with sexual orientation, gender identity. And there was always a vote on every amendment and then on the resolution as a whole. So certainly there is no global consensus on this issue, but it doesn't mean that at a domestic level this cannot be adopted as as administrative regulation as a group.
Okay, great. So I've got Dina and then Karina. Dina. And yes.
Thanks very much. Thank you for a wonderful panel. It's really brought alive the background and the content of these principles. I've tried not to read the principles as if I were an evangelical pedant. But given the fact that states are going to be some of the main interpreters of these principles, I feel I'm in rather good company. And the principle I wanted to focus on was principle 12. The right to education must be guaranteed even in times of public emergency and armed conflict. You don't mention in that bracket occupied territories, political occupation. I take it you didn't mean to exclude them from that, because I think elsewhere Principle 5 makes reference to international humanitarian law. But occupied territories are principally where, because of their duration, there is a fundamental need of ensuring these principles to be applied in that context. And I guess more fundamentally, I just wondered if you could share with us how much these different contexts of emergency, armed conflict, occupation might actually be said to affect the content of these rights, or to moderate the content of these rights, given that we're in particularly attenuated situations where we might not be able, resources or otherwise, to comply with them in the way you've outlined.
Okay. Want to tackle that?
I should say that there are specific principles on education that deals with education in armed conflict that they were started being adopted by experts and ended up being an intergovernmental process in which states can ratify and be part of it, and they can publicly adhere to these principles. So in a way, and they're very, very detailed set of principles. So this and go in detail to the situations that you were mentioning. So because this one we're more focusing on the issue of privatization, it did not analyze in details those issues, but these other principles are also very interested, and they have a very interested process in the way in which they started being developed by experts, and then it was taken up by states to promote them, and they created a very strange system in which states adhere to them, etc., etc.
You're talking about the Safe School Declaration, yes? It's the Safe School Declaration, which was endorsed by over 100 states, and it is now, it is treated, at least in the Council, almost as a hard international law, yes, because it was, it has such an endorsement by states, yes.
And it started like an expert principles, and then they were co-opted by states, and they have been very successful.
Yeah. Karina, please.
Thank you for a very interesting presentation, and I had a couple of questions for you. I'm wondering, to the extent that you're able to speak about it publicly, if you could tell us a little bit about the debate amongst the experts about precisely what position to take on privatization and how you arrived at what sounds like a rather nuanced position. And I'm wondering, just having looked at Philip Alston's report on privatization, where he takes a very strong view that I think suggests that there's something about privatization that is inherently a problem for human rights because it prioritizes other concerns than things like non-discrimination. And he also says that there's a problem that we're taking a piecemeal approach across the UN system. I'm wondering if you think, based on your experience, that we need to address this problem sector by sector, so in the education field, in the cultural rights field where I work, or we need some sort of guiding principles on privatization. We need to step back as UN system and look at this as a sort of larger problem and draw some conclusions. Thanks.
Some thoughts on privatization and how it operates in this space.
I can go first. I think that you need both. I mean, this principle shows that you need some sort of detailed discussion that cannot be done in an overall way, because there were many nuances that has been explained here, but in the way that how you implement. And if you look at some of the principles and the regulations that we're proposing are sometimes really very specific to education.
I think one of the reasons is that there isn't in international law a right to private healthcare, for example, or a liberty to establish a private healthcare. Whereas in the field of education, there is that liberty. And that liberty obviously came about because when the UDHR was developed, those things were brought to the table and people were worried about the power of the state working against minorities, religious minorities and others, and people who wanted to. I mean, we got lots of submissions from people who felt that we were encroaching unreasonably into their space. Montessori experts, for example, were very worried about this and so on. And I think on our committee there was a fair range of views on this. There was always a debate going on about this issue. It was something that troubled us. It was something that was like a little itchy thing at the back of your neck that you had to keep worrying about. But I think all of us understood that the state's obligation was what came first and that was central. There was nobody who didn't agree with that. But what those of us who were worried about it were worried about how the guidelines could be read and used by a state that actually had the wrong intentions to impose a form of education that would obliterate freedom. So I think that there were those concerns, but we were careful in our drafting, I think, to try to avoid.
I can set an anecdote from a different process, but I think that there was sort of the Abidjan Principles represent some sort of consensus. In the Yogyakarta Principle, 2007, the first one, for example, they don't include the right to same-sex marriage. Despite there was an issue that was raised, there was no consensus, so they did not include it. In Yogyakarta Plus 10, it was one of the issues that motivated to have a Plus 10 was that in the 10 years there have been many changes, and the first right that they needed to reincorporate was the same-sex marriage. And I think that in this one, I don't think that we will be forced to review them, at least not very soon, in the sense that there was something regarding privatization that we left out. I think that there was sufficient consensus, and hopefully they're going to last. Although if then we need to be more progressive, of course, and people over profit, in my view, it will be fantastic. But I think that the consensus and the balance was quite right.
Can I add a bit about the process? So, in a sense, what we had in our aim was commercialized private education, and so we often had as our paradigm kind of Bridge Academy rather than your kind of local church school or or education at home, or so when one of the big things we had to do right at the beginning, and many consultations, and Tom, who's here, who helped with the drafting, is at some of them, but some of us were at various of the consultations, and the big issue was, can we define private? So you may be looking through the document to see how we defined private, and in the end, we defined public rather than private. And I think really we did, all of us subscribe to a freedom from the state in the idea of education as a right to liberty from state-imposed propaganda. But what we really wanted was state regulation of commodification of education. And this was a discussion we had a lot. We couldn't really isolate only that as a privatization issue, but we wanted to leave space for state regulated, but other kinds of privatization.
Yeah.
I think it's important that the states understood what we were going to say. So, for example, during this discussion in Human Rights Council, Finland said about the Abidjan Principles, it's not about taking the choice away from the parents, but rather it's about the situation when the state delegates its core responsibility to the private sector and thus contributes to turning what is public good into a commercial project. And I think they captured it very, very nicely, and I think they understood. So probably we can't make it at the legal level, and this is my second point, but at the political level, the idea of excessive privatization is already there in SDGs. So are they anti-poverty and partnership? So this all can be read together to mean let's strengthen public provision. This would be kind of a political level rather than legal.
Thank you. Please, your name as well, please.
Hello. Thank you so much to all the panelists. My name is Nimisha. I am in the second year of the master's program at Oxford. This is, I have not read all of the principles, but just looking at the summary over here, looking at the second heading, the overarching principles 1 and 2, I found it really interesting that they talk about the right to education of everyone within the state's jurisdiction. And of course, I would understand the rationale that went behind it, but I wondered if there was any discussion amongst you about kind of severing or sort of diluting the relationship with the UNCRC, because you are kind of going away from the right of the child, and because UNCRC is such powerful international law, it's the most ratified treaty in the world. So I wondered if there was a discussion about that.
And you've got to start us off with that.
Yes.
Have you set up a competition to yourself?
I think essentially one of the reasons why it went broader was because obviously we didn't want to leave out all levels of education. And the other thing was that the plethora of international instruments that we were wanting to draw from was broader than the CRC. And so we wanted to be able to leverage from ISESCA and the general comments and so on from the other treaty bodies. So I think that decision was taken very early on, that we were talking about a full range. But you do, in certain places, you see that children kind of come to the fore, or schools come to the fore, whereas in other areas it is broader. But the intention was to be broad.
And just to add to that, there will be cohorts like women who might have missed out on education because of discrimination in their childhood. So we didn't want to leave out the possibility of adult education and everybody. In fact, ISESCA itself talks about everyone has the right to education, and it does refer to lifelong education.
Yes.
So we didn't want to make it exclusively necessarily about children.
Francois, please.
Francois Hampson, University of Essex. A comment, then 2 questions. The comment goes back to the point that was raised about privatisation. I think it may be useful to distinguish between the obligation to ensure that education is available and the obligation to provide it. Because if you can call something an intrinsic state function, and it's a bit difficult in the case of education because of the express provision for private education, but if you can find part of it that is an intrinsic state obligation, then the argument that arises in other contexts helps, and that is the state is legally liable for things done by privatized actors where it's within the sphere and it's direct liability. It's not failure to protect, it's direct, because that's a disincentive then for privatisation. So I've got a subversive agenda, but you don't need to admit that. The two queries. The first is to do with education in national minority languages, because I think that raises different challenges from some of the other discrimination issues. And the second question is the issue of how you teach history, because this is outside both what the state does and what the private sector does. It's to do with the controls on the content of education. I've always been interested in this anyway, but I'm on the Commission of Inquiry on Burundi, and Burundi is in the process of changing its history syllabus. Any comments you've got on that?
So, two specific questions there, I guess. One is on the national minority languages first, and the other, no.
Anyone can answer.
Joshua, you go for it.
Joshua, why don't you comment as well?
Well, I mean, I think in a sense, my role there was to look at precisely those kinds of issues. And I think that's the difficulty. So I would have had a very straightforward position saying privatization is an inherent bad in the context of a national education system, not only because it segregates, but because it diverts funds away from the importance of the state providing a standard product. But then, with the minority hat on, that becomes a challenge. Because your immediate challenge becomes, that means you get the mainstream majoritarian perspective on education. That means you get specific religious education as opposed to a range. And so that's the difficulty with it. So I think it's not just a minority languages question, which of course historically in terms of public international law goes back to the Belgian linguistics case. It's not just a question of minority language education, it's minorities per se and what room can be provided. And so I think if you take a harsh view on privatization education equals bad, you're essentially ruling out in many instances, not just the example that Anne gave about Nelson Mandela being forced to go to a particular type of school, but minorities generally across the globe being forced into a straitjacket where they can't propagate their own values. So I think the difficulty with the principles have tried to nuance it. That's been one of the factors that nuances the principles on the privatization question. Exactly that question about minority languages and minority religions.
The UK shows it can be done in Gaelic-speaking areas and Welsh-speaking areas. There are public schools that are teaching through the language in question.
No, absolutely, but not all the states that we're talking about have deep pockets and are Security Council members. So there's going to be the standard. I'm sorry, we don't have money for even our own populations. Never mind your minority populations who undermine the state. Anyway, that and the other question on the history, yeah, which is another very important question in forming mindsets.
The principles go into define what is quality education. And by defining quality education, it refers to, it's very broad, but it refers to curriculum, and it's also referred to the acceptability issue and required sort of human rights standards. In some other principles, also it regulates when a school that receives private funds, what they need to comply with. And again, there is some sort of content specific regulation. They're broad, but I will argue that several points can be used to argue the need of having sort of a curricula in line with human rights principles and standards.
I think what your question also about that reminds me of is that some things sort of fall outside of the scope, and that is we didn't really look at goods and services being privatized. So in other words, the provision of textbooks, stationery, transport services, school feeding, all of that is a little bit outside of the scope because I think it was just too much to try and deal with. So if anyone wants to start a new set of guiding principles, there is room.
First protocol, I think. Robbie, you have a question.
Yes. First of all, thank you as well. It's been so interesting. I just wanted to ask, like coming from a South African perspective, the states tried to introduce the outcomes-based education at the time, and that was seen as a lot of the private schools were really worried about. I'm sure you know about it. The results of that, and it was actually they still kept their private like matriculation board and that, and like as it turned out, the state level, they admitted later on that the outcome of based education wasn't of a sufficient standard. So I was just wondering, like, what standards you provided to ensure that the state education is still of a sufficiently high level.
Quality. So, I mean, I think we did make the point earlier that obviously we're not worried, Eton doesn't have to quake in its shoes over the Abidjan Principles. I think they're fine, we're not, too worried about what's going on there.
And it's not just because of legitimacy.
And what we're worried about is the problem of poor quality education. Well, two things. Poor quality education, which is dished up to children for a fee, and then other forms of fairly accessible private education, which leaves children out if their parents can't pay. So both of those things are problematic if some children are then left in a substandard public education system. So what you want is a functioning public education system. We're not interfering with the private education providers to provide their own curriculum if they want to, as long as it provides an equal standard of education. That's really essentially it.
The second question was, I don't know if you dealt with the right to tertiary education, and because that was also quite a big issue of the right to free tertiary education for all the student protests.
It was intended, the guidelines are intended to include tertiary education. Yeah.
Okay, we have two final questions, Bashak.
Thank you. So I'm just very curious about whether, what you thought about whether these guidelines will be relevant 20 years, 30 years from now. So the question is more about the future proofing of the guidelines and whether you had any discussions on that. I mean, for example, you make a reference to all applicable human rights law standards, and you were saying, well, we have a list there and we've really fleshed it out. But of course, 20, 30 years from now, we might have a different view on, right to free access to internet, or I don't know, there's lots of discussions on the uses, good and bad uses of technology, online courses, no contact time. There's quite a lot of discussions on what is the quality of education and so on, which bit is human rights, which bit isn't, and so on. So I'm just curious as to whether you had discussions on future-proofing your guidelines when you were drafting.
I don't think we did.
Well, there seems to be a process, like you mentioned, you could have 10, right? So in 10
they never thought about having a new Yogyakarta, and then 10 years later they had. But I think that implicitly, there is when these principles are discussed, you're always trying to sort of to balance whether or not you're going to be too progressive, whether I mean discussion. There were a lot of discussion of which terms you can leave more open-ended. So you leave some leverage for the document to grow itself, and it wasn't very explicit. Oh, less. I mean, what might happen in education in 20 years? But there were discussion about leaving some terms open-ended, not to be too restrictive, how to try the right balance. And because there was a lot of consultation, there was a lot of pressure from civil society organization, from all sorts. So some of them were terrified that we were dealing with private actors. Some wanted much more regulation. So there was always this kind of balance in different areas that I think that helps to have a constitutional process, if you want, of a document.
Also, I think we were very careful to refer to binding human rights documents that are already existing to give it the legitimacy. So we were, although there are open-ended terms in those documents themselves are kind of future-proofed, or at least are meant to be long-lasting. So I think that was also part of the thinking. We were binding ourselves to already existing international law standards.
Also, the guiding principles were trying to solve a particular problem, how to provide good quality education to those children in poorer maybe areas or poorer countries that don't have it, and in situations where the education system is totally occupied by corporate interests, for example. And it doesn't seem to be going away very soon, a situation like that. So we believe that as long as there are corporations, these guiding principles will work.
Yeah. A final question, please. Yes.
Thank you for a really great presentation. I had a couple of questions. Firstly, when you talk about the practice, you looked at best practice from multiple jurisdictions, and I was wondering if you came across any jurisdictions which, in their practice, were applying most or even many of the guiding principles. And linked to that, what do you see as major challenges to implementing these guiding principles within national jurisdictions?
Well, I guess it's early to say because not so many. We first need to focus on distribution of guiding principles before we can talk about implementation. There are only 2 cases at the moment when they were actually implemented at a domestic level. But the rest.
I think what we did notice was that around the table people would often bring the example of their own state to say, but actually in South Africa there's the private schools are already regulated in this way and this way. I mean, I wouldn't think, for example, that South Africa will have any difficulty implementing these guidelines. They already regulate private schools pretty much along these guidelines. But then we had some challenging ones like the Netherlands, where there's a high level of private sector involvement, but it's very equal. So most children can access the education system, and so we were testing against that. You don't want to come out and say that a functioning and good system is against your principles from the very first day. So those were debates that we constantly had, and we had some wording shifts and changes in order to try and deal with some of those.
Okay, colleagues, any final comments then with regards to the importance of the principles, their legal weight going forward, what they can do in terms of the right to education? You've got about 30 seconds each, I think, so it's a couple of sentences at best.
Well, I'll just quickly say that it was a very, very hard work of many people, and I believe that in the end we came up with a rather balanced solution. And the balance is also something that the states have noticed during the debate, that we recognize the liberty of parents to establish private schools, but at the same time we recognize the obligation of states to provide public education to everybody. And this balance has been achieved throughout the document. And I would like to say congratulations to all of us that this was possible. And thanks for this event.
Thank you, Maria. And Kamalina?
I just the last question is still resonating in my head, and my own personal view is it's that we are fighting corporations. I mean, the British Academy are very profitable companies that are taking over countries in several regions of the world because they're making money. And they are there because they're making money, and if they're not making money, they just take their iPads and they leave. And because they don't train teachers, they just give them an iPad. And then they leave people children in a very bad situation. And fighting corruption is very tough, and fighting corruption within the human rights framework is even tougher. So this is a small contribution, but it's the David against the Goliath, you know?
Stirring words. Sandy?
Yes, well, I think it's well known that education is the best pathway out of poverty. And the fact that we are still seeing so many children out of school and so many children not having access to quality education is a really strong motivation to see what are the barriers. And I think for me, as well as fighting the corporations, the really strong point about these principles is to reassert state responsibility, that education as a public good, that everyone has a right to quality education, and that the first port of call must be the state, whether by providing good public education or regulating private providers. But through the process, because we started off in a sense fighting corporations, it ended up strongly affirming the state as the central body responsible for fulfilling the right that every single person should have.
Well, let me bring it back to this academic audience and say, there's only one journal article that's been written about the Abidjan Principles, no doctoral theses or master's theses have yet been written. So it's a big open empty space for anyone who would like to contribute to these debates.
We have Tom, who's nearly finished his doctoral
yes.
Tom's
So
nearly
Tom's
there.
ahead of the rest of you.
Colleagues, it has been an absolute pleasure. I think, first of all, thank you for the vision that led you to this particular process and for the outcome document, which is impressive because it negotiates so many difficult spaces, and it negotiates well. And some part of me is delighted that it's got traction. Another part of me thinks maybe we could have gone a bit further, pushed it a little bit further. But thank you very much for participating. I hope you'll join me in expressing our thank you in the traditional way.